Today's going to be a mix. There's going to be, first of all, a very serious analysis of a couple of large commercial decisions and the uses and abuses of commercial suppression in that particular context. And then we're going to move to the fun stuff, which is what's been going on in Victoria for the last year or so with the security case, Gobbo, Pell and the like. It's not all fun and games. The reality is that you can use suppression as a very effective litigation tool under the right circumstances. And that's a very cynical thing to say, but it also happens to be, unfortunately, very true. The other thing that you need to know about suppression these days is it is now becoming a feature of the larger commercial cases, and it's quite dicey to handle. In the last 12 months, I've had problems with two separate suppression orders granted by two Supreme Court judges, where there has been a great deal of uncertainty among the solicitors and the barristers about exactly what we could and could not do, what evidence we could and could not lead, and what we could and could not tell our clients about it. So there is look, it's a fascinating topic. It's an obscure topic compared to the standard stuff that we do in these chambers in the CLEs. So thanks for being curious cats and coming. But there is a serious side to it. I'm going to hand over to Julie to start. Look, there's going to be a bit of toing and froing between the two of us. We're both meant to stand in this position because there's a camera streaming us. I've already told people that we will be moving about. We will be throwing the ball around a bit. But I'll hand over to Julie now.
Thanks very much. So I'm going to do a bit of the sort of boring introduction stuff and leave the fun stuff to Tony. So just kicking off, what are we going to cover? I'm going to give you a bit of an introduction to suppression orders. What's it all about? Why do you get them? When do you get them? What are they for? Talk to you about the orderly conduct of commerce, which is one of the sort of guiding principles that comes out of one of the leading cases as to the circumstances in which you can get one and what the court's trying to protect when it gives a suppression order. And then contempt and the fun stuff will be over to Tony. So what's a suppression order? So if you're practicing in New South Wales, whether you're in the Supreme Court or the Federal Court, these are the two statutes you need to have a look at. Federal Court of Australia Act, Section 37AA, and the Court Suppression and Non-Publication Orders Act in New South Wales. Now, they both contain that same definition. A suppression order means an order that prohibits or restricts the disclosure of information by publication or otherwise. So that's our starting position. Now, what are the grounds for making an order? Now, this is the list in the Federal Court Act, and that's what I'm going to keep talking about, the federal legislation. It's almost identical in New South Wales, but I'll just talk about that one today. As you can see, that they are the grounds to prevent the prejudice to the proper administration of justice, to prevent prejudice to the interests of the Commonwealth, state or territory, so that's a national security issue, protect the safety of any person, or to avoid causing undue stress or embarrassment to a party or a witness in criminal sexual assault proceedings. There's one additional ground in New South Wales legislation, which is otherwise necessary in the public interest. Now, if you are a commercial party looking to keep something suppressed, you're probably interested in the first one, to prevent the prejudice to the proper administration of justice. And I'll go through that in a bit more detail in a second. You can see the other ones are far more specific, and they would only be used in specific circumstances. But the one that we come across the most is the first one. So what do we mean by prevent proper administration of justice? Well, first of all, it's got to be necessary. Okay, so you need to establish that it's necessary to prevent prejudice to the proper administration of justice that you get this order. That's a high standard, and the cases tell us that it's very high standard. It's going to be a lot more than less demanding standards, such as whether the order would be convenient, whether it would be reasonable or sensible. It's not going to be concerned with trivialities. So the mere fact that a particular party may say that commercially it would be an embarrassment to them or it would cause them some unfortunate financial effect, that might not be enough. You've got to really start with getting over this high hurdle. And the administration of justice category is not just focused on the court system or how the judicial system operates. It's much wider than that, and it takes the commercial affairs of different parties into consideration. It's also clear that from the cases that we've heard on this so far, that whatever is meant by the interests of justice is not a closed case. So the cases that have been on this, that have looked at different categories of what might fall within this, are not over. Every time there's a different set of facts, the court's prepared to look at this again. So there is no closing of what might be covered by this. So what kind of things do the court think is appropriate? Well, firstly, it's appropriate to make a suppression order where it will protect the orderly conduct of commerce. And the case, one of the leading cases in this area that comes from is the Betfair and Racing New South Wales case. It's also to prevent the revelation or leaking of trade secrets to competitors. Now, that's a very common area in which suppression orders are made, and I'll talk to you a bit more about that in a second. Or the disclosure of market-sensitive information which would be of significant value to trade rivals. It's also to ensure that obligations of confidence be not lightly overruled and legitimate expectations of confidentiality as to private affairs be not lightly disregarded. And that's the ACCC and Air New Zealand. So, give you a working example. This is the case of Novartis Pharmaceuticals and Bayer Australia. And this is a case that I was in a few years ago. This was the first time I'd ever worked for a big pharmaceutical. I don't know if any of you here work for big pharma, but I found it quite eye-opening. Big pharma seem to have more money than God, and they hate each other. So if you're a litigator, that's absolutely fantastic, because these people are going to fight to the death. And they are very serious rivals. You know, this is more than Coke and Pepsi, it's more than Ford and Holden, it is Batman versus Superman, it is Marvel versus DC. These people are absolute, guns at 50 paces. So in this case, the claim by the baddies, Novartis, because I was for Bayer, was that Bayer had introduced a drug and had engaged in misleading and deceptive conduct about how they advertised the drug. And these two drugs were the only two drugs in the market at that time that did the thing that they do. So before Bayer introduced its drug, Novartis was the sole, owned the market in this area. And the market is a drug to prevent an eye condition called wet AMD, which I can't even begin to pretend that I understand, but basically means you start seeing spots and eventually you lose your sight. So it's a serious condition. Happens to more people than you would imagine, given that probably none of us have ever heard of it before today. And, it's quite common in the over 50s and towards death. So something to look forward to for all of us. It's a serious condition and there doesn't seem to be any way to stop it. So it just occurs. So what, as a country, the government says, well, okay, if it's going to occur, we have to work out how to treat it. And so on the market, Novartis had a drug that effectively stops it, halts it from getting any worse. Pretty nasty application. It involves an injection into your eyeball. Fantastic. I'm not sure if I'd rather go blind than have an injection in my eyeball. It's got to be touch and go. This is an extremely, extremely lucrative market. The drug that Novartis had on the market was prescribed on what's called the PBS here, which is the Pharmaceutical Benefit Scheme, and that means if you need that drug, the government pays for it, in essence. So once they've got this product up and running, it's really a license to print money, because if you need this drug and you have this injection, you have it once a month for the rest of your life. So big deal. Every injection costs a lot of money, as you can see. There's a lot in this. So there was Novartis sitting happily on the market with this drug, having the time of its life. Bayer pops up with a rival product. Not only do these two people already hate each other, but now we've got somebody coming to scoop out half of this lucrative market. So Novartis said, not only don't we like you, Bayer, but we say that your drug, you've falsely advertised it. Now in Australia, as you probably know, drugs like this can't be marketed to idiots like me, because I might say, oh, that sounds good, I'll have one of those. They can only be marketed to the professionals who prescribe them. So it doesn't really matter what anyone says about these drugs to us. We are not the target audience. The only target audience is an ophthalmologist in this case, which is not the person you see for your eye test, but the surgeon who would operate on your eye if you need an operation. Now, at the time that this case was going on, there were only about 400 ophthalmologists in Australia. So that is a very targeted market. And these people take their targeting of those people very seriously. So by which I mean they've all got, Novartis and Bayer have got sales reps who are very cleverly set up in particular areas to go and see specific ophthalmologists and try to convince them that, my drug's better than that drug or whatever it is they do. And this is, because it's so lucrative, And because if an ophthalmologist says, I'd like to use the Bayer drug instead of a Novartis drug, that's what will happen. This is a really highly fought area. And so you've got ophthalmologists being targeted by people from both sides on a, pretty regular basis. And they're very clever about the way they do it, and they retain information about the different ophthalmologists. This one's got a son who plays chess or whatever, or this one likes to play golf. All of that sort of very personal data that both companies collect on this target market, because this is such a highly competitive area. So the claim was, you've misled these ophthalmologists by advertising this drug in a particular way. And the complaint of advert was that if you use the Bayer drug, you might not have to have quite as many injections. So, for example, in the first year, you might only have 10 injections instead of 12. Now, you can see why that would be very attractive to any patient who's having an injection in their eyeball. Less injections, got to be a good thing. But the patient isn't the market, it's the ophthalmologist. So the question about whether or not advertising the drug in that way was misleading and deceptive. Now, we had 3 or 4 highly fought interlocutory fights about all sorts of boring things that have got nothing to do with suppression orders, because this is such a highly fought and a highly fraught area. But the suppression order issue came out when we, Bayer, had to disclose the evidence of what our sales reps said to the doctors, so that the court could work out whether or not that was misleading and deceptive. So all the different things they discussed with the ophthalmologists when they go to see them and say, this is why you should prescribe the very expensive Bayer drug instead of the very expensive Novartis drug. Now, the data in which Bayer, the data that Bayer recorded was all in a central database, and it was the notes taken by each salesperson when they saw each ophthalmologist. And some of it was, this guy's got a son who plays chess. Some of it was, this woman likes to play golf on a Wednesday. Some of it was, this guy's always been a Novartis person. How do we persuade him to Bayer? Some of it was, this guy's really keen on safety. We need to give him more safety data. Very, very targeted. Loads and loads of it, pages and pages of it, going over a long period of time. Now, you can see why that would have been absolute gold to Novartis. Now, they've got their own sales force who are out there trying to do the same thing, but here is a gift of a piece of information if they get their hands on it. This is exactly how our trade rivals do business. This is how they target the ophthalmologist. This is what they're discussing with them. This is what they've recorded that means a lot to that ophthalmologist, and what that one doesn't like, and what this one will prescribe, and so on. It was absolute gold. So Bayer sought an order that it didn't have to disclose this massive database of notes of ophthalmologist discussions to Novartis. So it would only be disclosed to the legal team, which is quite a common result of a suppression order. And it was highly fought, but in the end, it was granted, because this is the classic sort of trade rivalry case. You could see that the judge was pretty easily convinced in the end of what a huge advantage that would give to Novartis. This is a duopoly. There's only 2 players in this market. It is worth a truckload of money, and it would give Novartis a huge advantage over Bayer if they got their hands on these notes. So that was the order made in that case. One other thing I'll just say about the last bullet point there, detailed and current information. This was right up to date. The information was being collected on a weekly basis, and it was right up to the date of the hearing. A court is not very interested in old data. So if the data we'd been fighting about was more than 3 or 4 years old, perhaps 5, 6, 7 years old, or really old, far less likely to get traction with a suppression order, because it loses its relevance. It's not current anymore. The ophthalmologists change or whatever. The court's far more interested in something that's right up to date. So this is what the finding was in the end. Talking about why it was that the detail aid, which was like an iPad that the sales reps used to use to talk the ophthalmologist through their product, and why it was found that those particular people were going to provide Novartis with a massive step forward, massive advantage if they were given that. Now, that information that was suppressed, and also some other information that was subject to a different order, stayed suppressed for the whole hearing. So what does that mean when you get to a judgment, and a judge who has to write a judgment on information, a whole stack of which is suppressed? And the answer is, you get a judgment that has, when you go and look at it online, and you can go and look this one up if you want to, a whole stack of blank pages in it. So if I Oh, no, that's yours. I'll take you back there in a second. If you go and look up this judgment, there's a whole stack of pages that just has big X's. And you can't read that part of the judgment, there's just big gaps in it. And that is what it looks like until the end of the suppression order. I can't recall when this one ends, but they are given an end date, and the end date will be when that information is probably so old that it really doesn't matter. In 10 years' time, or whatever it is, if Novartis finds out what Bayer was saying to ophthalmologists 3 years ago, who cares? But whilst it's current, and while these drugs are so current and in the market, it does matter, and that's what the court judgment looks like. Now, a couple of practical tips if you've got a trial where this is happening. It's very easy to lose track of those things. Like Tony was just saying, sometimes it's not very clear what is and what isn't suppressed and what you can and can't say. It was clear in this case, but that doesn't mean it's easy to keep track of it. It's not. If you're getting a witness in the witness box and they're either your own witness and you're leading evidence from them, or you're cross-examining them because on the other side, if they're going to start to stray into territory that reveals confidential information, and if it's your confidential information, then you need to make sure that you take whatever steps are appropriate to make sure that that part of the evidence is also treated as confidential. So you usually need to say to the judge, Your Honour, can we please go into confidential session now? And the judge will then say to the transcript writer, we are now going into confidential session. And anyone who's in there who's not entitled to listen to that information, so for example the clients, have to leave the room. And the door is shut, the court is actually closed, and they can't come back until you go back to talking about evidence that is not the subject of the suppression order. So you've got to keep an eye on that. Otherwise, if you accidentally, don't make that happen, then the suppression order that was in place is not going to do you any good. Once that evidence is open, it's open. The same thing goes for documents. So if you are taking a witness to a document that's confidential, again, you need to make sure that the transcript and the court goes into closed session for the purposes of discussing that document. And also, if you are taking the court to a document or tendering a document, if that document is the subject of a suppression order, you need to make sure that when you hand it up or when you discuss it, it's noted that that is the subject of a suppression order, and that any reference to that will be kept confidential. A practical top tip, I think, for doing that is print them on a different coloured piece of paper. If you've got an enormous trial bundle which has got some confidential material in it and some that's not, it's going to be really difficult to work that out on the day and pick up a piece of paper and not know unless it's on a different piece of coloured paper. So just print it on another coloured paper, and then you'll always know that whatever it is that you're talking about needs to be kept confidential, and you need to make the court aware of that. All right, unless anyone has any questions on that, I will hand over to the more fun part of the talk.
I'll start by extrapolating on exactly what Julie was just talking about. I have here a decision of the Victorian Court of Appeal handed down a month ago. I don't have it on screen, but what you'll see visually is quite the word redacted at paragraph 79, 80 saying, nevertheless, our early conclusions mean that blah, 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 and then 81 redacted, 82 redacted, 83 redacted. So that's what the judgments themselves will look like. The judgments will either have they'll either have blackout in them, or as in this one, which I'm going to turn to in a minute, they will actually have redactions in them. Now, when you have a judgment like this, which is a Court of Appeal judgment with the word redacted in it, this is the decision I'm looking at the moment, the Gobbo one, the decision of the Court of Appeal in Gobbo to basically reveal. It was the one that was on the road to the fact that her name should be identified. There is nothing in this judgment which would indicate why those paragraphs have been redacted. What you do when you see that is you draw an inference. And you draw an inference there is in fact another suppression order in existence, which means that those paragraphs cannot be revealed. You don't blunder around in the courtroom guessing. You don't speculate about why those paragraphs are redacted. You just immediately draw the inference that for some reason there is an undisclosed suppression order which is actually affecting those paragraphs. The first time I read this judgment, I was tremendously frustrated because obviously the logic of the decision doesn't make sense when it's therefore blah, 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 and the 5 previous paragraphs have been redacted. There is no therefore under those circumstances, like, thanks very much for giving me a wrapped up conclusion. But the reality is that there must be a ground under the Open Courts Act or under the general common law principles of suppression, which mean that the Court of Appeal, which is a sensible court, a genuinely sensible court, has made that decision to present practitioners and the general public with a decision in this form. In a commercial context, and again, I want to deal with the commercial context in a bit more detail before we turn to the fun stuff. It is incredibly difficult to run an application in circumstances where there are suppressed materials. Because suppression doesn't necessarily, the courts are loath to kick everyone out of a courtroom. I'm going to put you in the Supreme Court before an extraordinarily sensible and well-regarded judge who bends over backwards to preserve the open courts principle, which is the law of the land. Open courts wherever possible. A commercial matter of such sensitivity that the mere existence of the thing, and even the mere mention of the thing, would have revealed a multi-billion-dollar trade secret. You're warned when you walk into court by opposing counsel, or should I say by counsel who's intervening, hold on to your hats. That's you're given warning. And then what you hear is counsel stand up and say to the judge, are you willing to exclude media from the courtroom? And the judge says, this matter is already suppressed, so you need have no fear. And then what counsel says is, look, I know that this matter is already suppressed and therefore nothing that we are doing today can be reported. But at some point in time, that suppression order is going to be lifted. So, and I'll come to the case that I'm referring to in a minute. The suppression order is going to be lifted. Are you willing to exclude media? All hell breaks loose, media applications everywhere. An hour and a half later, after the media effectively put counsel who was intervening on the spot saying, why are you doing this? And counsel said, I can't disclose it because to disclose it would reveal the existence of the thing. The judge says, very well, I'm not going to remove the media from the room. I'm going to insist that the application proceed, and you, counsel, are going to have to do the best that you can. And what the barrister did was actually extraordinarily skillful. He handed a bundle to me, he handed a bundle to the other party at the bar table, and he handed a bundle to the judge, and he said, I want you to turn to paragraph 22. I want you to read paragraph 22. Everything that I say to you for the next hour relates to paragraph 22. But I don't want anyone here at the bar table, or alternatively on the bench, to mention what paragraph 22 is. And it was extraordinary how he did it. It was extraordinarily disciplined. He was extraordinarily stressed. And yet, I looked at paragraph 22 and thought, yeah, here we go. Read paragraph 22 and thought, all right, I understand exactly why you're doing what you're doing. And clearly the judge had exactly the same reaction, read paragraph 22 and thought, yep, this is the world's most obvious case of the mere existence of the thing. The fact that this thing even exists would be an extraordinary breach of a trade secret. And you can guess that we're dealing with the tech sector here. And that's the way the application was run. There was a large, Mr. Thomas, what do you say about paragraph 22? And that's when you sort of barf in a bag and then stand up and try and address the court about paragraph 22 as best as you humanly can without breaching 9 separate suppression orders. But at the end of the day, the right result was achieved, and the judgment itself has been fully suppressed. The existence of the judgment has also been fully suppressed. So and that's something that is happening in the words super injunction are ones that you've read about in the media, and I'll come to what a super injunction is in a minute because they're truly fascinating, and there is an attempt by the courts in Australia to say, well, there is no such thing as a super injunction. Maybe so, but an injunction which has the practical effect of a super injunction is well and truly in existence in Australia at the moment. Okay, the slide is entitled, When You're in the Thick of It, What Do You Do? unbeknownst to the public, except when WikiLeaks blew it all over the front page of every international publication, Australia's biggest bribery prosecution, called the Reserve Bank security scandal, was finally revealed on November 28, 2018. Those of us who are involved in it, it is basically the biggest white-collar criminal/commercial case in Australia's history, and its existence was fundamentally suppressed for the duration. There were fines, there were a number of guilty pleas, but the reason I'm interested in it is to look at the ways in which the court dealt with a complete violation of the suppression orders. And that violation took place in 2014 when WikiLeaks, who are quite a big player on the scene these days and are a danger to both commercial and criminal lawyers alike, and their competitors are a danger to commercial and criminal lawyers alike, published the existence of a secret court order. The case, for those of you who practice in this field, is DPP and Brady, and it's a decision of Justice Hollingworth of the Victorian Supreme Court. What the security case is, it's the allegations that lay at the heart of security were that various executives of companies who were selling polymer banknotes, marketing poly banknotes to the polymer banknotes to the governments of, among other places, Vietnam and other Southeastern Asian, Vietnam, Malaysia and other nations, were engaging in bribery through the use of agents who were well connected, and that the Australian executives knew or ought to have known that they were being participants to bribes, that the people they were using as their agents were involved in bribery. Now, polymer banknotes are a huge Australian export. We are the world leaders in polymer banknotes, and the orders that were coming in from these Southeastern Asian nations were for 5 billion banknotes, 10 billion banknotes. It was the volume was quite extraordinary, and the profits were and are and remain quite extraordinary. So there is both a criminal and a commercial aspect to all of these cases. DFAT got involved. DFAT raised its hand and said that the fact of the allegations that Australian executives had been involved in the bribery of Malaysians, Vietnamese and other officials would be embarrassing to Australia's foreign relations and could potentially compromise Australia's security. This is the subject of DPP. This is the subject of DPP and Brady. DFAT proposed an order which they described as being a specific purpose suppression order, although arguably its effect was that of a general suppression order. Here's what a general suppression order is. A general suppression order is one which says you cannot say anything about the identity of Informer 3838. You cannot publish even the existence of the fact that there is a person called Informer 3838. You cannot publish anything relating to the prosecution of an Australian Catholic Archbishop. There is to be no mention of the prosecution of an Australian Catholic Archbishop. That is a general suppression order. A specific suppression order is where you do this. You can publish the fact that an Australian Catholic Archbishop is being prosecuted, but what you cannot do is report the who, what and where of the allegations. So that's a perfect example of the difference between a general one, thou shalt not publish at all, and a specific one, which is thou shalt publish certain things, but thou shalt leave out others. And again, there is a total overlap between the commercial jurisdiction and the criminal jurisdiction here. When you're in the commercial context and you're trying to protect a client's trade secrets, you should always try and frame the order as a specific one. You should never try and frame it as a general one, quite simply because you will fail. The only way that you will get up on a suppression order in a commercial context is if you tailor it very, very carefully and you set out precisely the grounds upon which you seek, administration of justice being the most obvious one, protection of commercial conduct, orderly conduct of commerce, and then set out the consequences of what will happen if. Now, in this case, DFAT said this. DFAT sought an order listing 14 specific individuals, being persons who are highly influential in the governments of Malaysia, Indonesia and Vietnam, or their close relatives, and 3 political officers, the named persons. DFAT's concern was that the publication of the suppressed information in relation to the named persons would offend or embarrass them in circumstances that may have adverse consequences for Australia. These adverse consequences include putting at risk cooperation between the Australian government and the governments of Malaysia, Indonesia and Vietnam in areas of defence, security, counter-terrorism, transnational crime and law enforcement, including extradition and mutual assistance requests. DFAT sought the order. The order was granted, but the judge granted the order on the following grounds: that it was necessary, A, to avoid a real and substantial risk of prejudice to the proper administration of justice, B, to prevent prejudice to the interests of the Commonwealth in relation to national security, and did not actually go to the more specific ground of embarrassment, which is interesting, because frankly the DFAT application relied on the general ground of embarrassment. One can never infer what is going on in a judge's mind, but there was an unusual discrepancy between the grounds upon which that order was sought and then the grounds upon which that order was granted. Fast forward, WikiLeaks publishes the DFAT order itself in 2014. The fact of the DFAT order was itself suppressed. So there was a double suppression. There was a suppression of the things, namely the identity of the Malaysian, Indonesian and Vietnamese individuals, and there was also suppression of the thing itself, namely there was a suppression order in existence. The order was sealed in an envelope and it was kept by the court, and then a year later it winds up in WikiLeaks on the front page of any number of newspapers. To this day, inquiries are being made how that happened, but it's an unusual set of circumstances where shall we say, it was a sobering lesson for all of us who put things in envelopes and give them to courts. On 29 July 2014, I'm reading from Justice Hollingworth's judgment. On 29 July 2014, WikiLeaks published the DFAT orders on their website in breach of the court orders. It was published together with a press release headed, "Australia bans reporting of multinational corruption case involving Indonesia, Indonesia and Vietnam." The press release was full of sensational, inaccurate allegations about the DFAT order, which will be discussed shortly. Fast forward to the end of the judgment. At the end of the judgment, Justice Hollingworth exercised her discretion to say effectively that the cat was out of the bag, and that because WikiLeaks had published this information, there was no point any longer suppressing the fact of the DFAT order and the fact of the information contained therein. It was a very sophisticated judgment because quite obviously it could be read as promoting a harm. The harm being that if you go out and catastrophically breach a suppression order, then a court will then not hold on to the suppression order any further. The judge dealt with that very simply by saying that the criminal prosecution of the matter of WikiLeaks' criminal liability for what it did is an entirely separate issue. Let's leave that to one side and let's dispassionately look at whether it is still in the interests of justice to maintain this order in place. She made some interesting observations about super injunctions. My notes on her judgment are, on paragraph 47, I've written the word super injunction. On another paragraph, I've written the word bullshit. On the next paragraph, I've written super injunction. What she says about super injunction is this. She says, publications by news media organisations in Australia did not directly breach the DFAT order by setting out its actual terms. Instead, most of the local media spoke in terms of WikiLeaks having exposed or revealed the existence of what they erroneously described in colourful terms, such as a super injunction, a super gag order, a blanket ban, or a blanket censorship order. In fact, WikiLeaks did not expose or reveal the existence of the order. The court had already informed the Australian media of the DFAT order, and more than 5 weeks before, in the circumstances described earlier in these reasons. Apart from Fairfax, none of the Australian media had even contacted the court to find out why the order had been made, far less sought to exercise their rights to challenge it. So, step number 1 in the judge's analysis is it's not a super injunction because I let the media know about it. 5 weeks before this thing hit WikiLeaks, I, being the court, let the media know about it. Now, that's quite different from the public knowing about it. The media itself was told there is an order, but you can't say anything about it. So that's step number 1 in the judge's reasoning. She continues. Commentators seem to have used labels like super injunction and blanket ban because they relied uncritically on the false assertions by WikiLeaks that the DFAT order was a blanket censorship order, one which forbids any disclosures by publication or otherwise of any information relating to the court case by anyone, including the Australian media, ensuring complete secrecy around the largest corruption case in Australia. The DFAT order does no such thing. My next paragraph's got the word bullshit next to it. There is a fundamental discrepancy between this judgment here and what you see there. What you see there is, in 2018, Australia's biggest bribery scandal being finally revealed. What you have in 2014 in Justice Hollingworth's judgment is her using reductive logic to say that there is that the suppression order that she planted in place was not a super injunction. I can't criticise her logic. She's right. The DFAT order itself was not the problem. The problem was the broader suppression orders that lay on top of that DFAT order. The DFAT order was merely one of a matrix of suppression orders. So her criticism of media outlets it's a very well-reasoned judgment. She reaches, in my view, the exact right conclusion. But some of her commentary about super injunctions and media irresponsibility, I think on a fair reading, is too harsh. It's an influential judgment, and it is cited a lot. I've cited it many times, but it's one that I cite very carefully because the reality is that it's quite fair when she says the DFAT order itself didn't stop all discussion of this bribery case. She's quite right. But the other suppression orders, some of which one could infer are still in place today, notwithstanding that headline, in fact does stop it. So there is an effectively made up of a series of small injunctions and the small orders. There was a perfectly contained super injunction. There was a perfectly contained super injunction in place. And a super injunction is, for want of a better word, a package of injunctions or a single injunction which prevents all discussion of the thing. Pell is a classic example of it. There was in fact a package of orders that stopped all discussion of the fact of Pell. It was a very well kept secret within the legal community. It was a very well kept secret even in chambers in Melbourne. My chambers in Melbourne are literally right next door to Robert Richter's. He and I share a wall, and I did not know that trial was going on. The only time I found out that trial was going on was when our shared secretary, I said, "Is Robert all right?" And she said, "Oh, he's doing the closing address in Pell," and then basically turned white and threw up in a bag because she realised what she'd done. But it was an extraordinarily successful series of suppression orders. And the reason it was so extraordinarily successful is because it was founded on an impeccable principle. The principle in Pell was basically the same one that was used in DPP and Brady / the security case, which is that if a future jury becomes aware of the facts that exist on trial X, then it will not be possible for the future jury to be able to do its job or to be seen to do its job in a fair and objective manner. And that's where the press got the Pell injunction wrong. That's where the press got the Pell contempt proceedings wrong. Sorry, the Pell suppression order wrong. Because the reality is that the press accepted the suppression order that was put in place in Pell because Pell faced another trial. Pell himself had two trials. He'd had a trial back in September, which had failed. There was a hung jury. Then he had his second trial, which is the one that convicted him, but there was a third trial coming up in March. And it is the most banal, obvious, and acceptable of grounds for putting a suppression order in place that there is a future trial coming up which could prejudice the administration of justice vis-a-vis the charged person. So in Pell's case, what Chief Justice Kidd did was entirely appropriate. The difficulty is that we live in a world where foreign publications do not necessarily respect the suppression orders granted by an Australian court. It is notorious that on the day that Pell was found guilty, Twitter traffic spiked extraordinarily around Pell conviction, and for those of us who were tipped off about it on that morning, it was fascinating to watch all roads leading. It hit a couple of minority US websites, and then gradually it made its way to the Washington Post, and it went on from there.
Same day, I think it made the Washington Post.
On this exactly right, it was about 8 hours later it hit the Post.
And Wikipedia, Pell's Wikipedia page was updated to say he's now a convicted person, and with a footnote to the Washington Post on the same day.
Which is arguably in breach of, it's not arguably, it is quite clearly in breach of the Australian order. Jeffrey Robertson ran a case relating to Dow Jones, trying to show that, effectively trying to create a worldwide injunction out of an Australian incident. And the jurisprudence on this is yet to be settled. But what we can see from Pell is this, that there is no attempt being made to prosecute any foreign journalists, and from that we must infer that the Open Courts Act / the common law principles do not have an extraterritorial application. Where the poor bloody journalists have run into problems is, of course, that a lot of them have reported the fact of the overseas coverage. The day after the Washington Post article, the Herald Sun notoriously came up with a black headline page, as did the Daily Telegraph, saying, it's the biggest story of the year, but we can't tell you. Journalists then referred to internet traffic spiking. They referred to the fact of overseas publication, and what they did was they did just enough to enable people to use those articles that they'd written to find the source and find the underlying story. The Daily Telegraph story was extraordinary in the way it did it. It was almost, I think we'll find it was set up when evidence is ultimately heard, because 30 journalists have been charged with contempt, or have been asked to show cause while they shouldn't be charged with contempt, I should say. It had all of the hallmarks of a coordinated campaign by the media to actually test the extremities of our suppression order regimes in Australia. 30 journalists have been given show cause notices by the Victorian Director of Public Prosecutions, and the judge in question, Chief Justice Kidd, has said that the journalists face the real prospect of imprisonment, and indeed substantial imprisonment, if found guilty of contempt. One of the fun games is to be aware of gossip. One of the fun games is to spread gossip. It was extraordinary, the pull that came over the bar in Melbourne the day this decision came out. Everyone was scared, because the general view was that anyone who disseminated the name Pell, if it could be said that Tony Thomas said it's Pell, then that somehow I, or whoever the informant was, could potentially be charged with disseminating the information itself. What we have here, and Pell will be the great test of our open courts policies in Australia. Because of the coordinated nature of it, there will only be one of two outcomes, which is that the journalists will collectively be charged with contempt and they will have a very difficult time of it, or alternatively, the director will exercise her discretion, or alternatively, the judge will find that the journalists acted in a way which was not sufficient to effectively pervert the course of justice and or undermine the administration of justice. The test for the judge is really going to be, was the order breached? That's really going to be the test. Did these journalists do enough to breach that order? Now, the reader who does not have Google, sitting there like Mr. and Mrs. Amadio at the kitchen table, could not find out the identity of Pell. But everyone knows that the readers do have Google. And the journalists will be cross-examined about whether they knew that the reader who received that article would then go forth and use Google and find out what the story was. And the fact of the Twitter traffic, which occurred within the hours after the judgment was handed down, and within the hours after those mastheads were published, is going to be used as evidence in the proceedings to show that the only inference that can be drawn is that these headlines about a giant suppressed matter led to the fact of searches for the name Pell, and then found in overseas publications the fact of the guilty convictions. Now, we're dealing with serious stakes here. We're dealing with 5 years imprisonment in Victoria. Here in New South Wales, we're dealing with less. The difficulty is this. I'm delivering this lecture in Sydney, but rather like the Daily Telegraph, published in Sydney, I have an online presence in Melbourne, and therefore the Daily Telegraph is not facing 12 months. The Daily Telegraph is facing the 5 years. It is the online, it's where it is published that counts. So we find ourselves in this new sphere where it's all very well and good. We always tend to think of law in jurisdictional terms, that it's a Sydney matter or it's a Melbourne matter. In this commercial confidence / criminal in confidence, it's a national matter. You actually have to be aware of the regimes in every state. Victoria and New South Wales are the only two for your purposes. Basically, the other states will mimic them. But it has much broader implications than merely the Daily Telegraph published in Sydney, which of course is then able to be found quite easily in Melbourne, will find itself the subject of prosecution. There's a reform attempt in place. The Open Courts and Other Acts Amendment Bill in 2019. Now again, it's Victorian, but that which happens in Victoria is leading the nation in this jurisprudence, and that which happens in Victoria will be followed in the other jurisdictions, principally New South Wales. The second reading speech is all very wonderful. It went through Parliament on the 20th of February. It's very aspirational, and it's designed to make you feel as though the days of open justice are upon us again. Courts will have to give reasons for making suppression orders, outlining the basis upon which they're made, their duration, and the scope of information that they cover. And closed court orders may only be used when necessary, such as where the publication of information would be unfair or risk harming victims or other parties. I just want you to look at the word unfair. Section 4 of the Act, which we can assume will head through Parliament sometime in the next couple of months. The principle of open justice prevails unless circumstances require displacement. A court or tribunal is to have regard to the primacy of the principle of open justice and the free communication and disclosure of information in determining whether to make a suppression order. A court or tribunal is only to make a suppression order if satisfied that the specific circumstances of a case make it necessary to override or displace the principle of open justice and the free communication and disclosure of information. Julie and I deliver a far less obscure and far more populous sequence of lectures on expert evidence. They started with the reform package that was announced 3 years ago, which suggested that expert evidence in Australia was going to effectively be overhauled and that we were going to enter a nirvana of experts who behaved like experts assisting the court. If one was going to prognosticate, one would read that and one would think, yes, this has all of the right intentions, but the reality is that 4.2 has got so much leeway in it that the principles that currently apply to the granting of a suppression order could all fit within 4.2. The specific circumstances of a case make it necessary to override or displace the principle of over-justice and the free communication and disclosure of information. Justice Hollingworth was confronted in Brady with affidavit material from DFAT, which she had no reason or really no ability to second guess, which said that if you do not suppress, then the following consequences will occur. Justice Hollingworth is a very fine judge. She is not an expert in the field of foreign relations. She had no reason to go behind the affidavit material that was put in front of her. And therefore, the carefully crafted affidavit material which was put in front of her effectively compelled her to exercise her discretion to grant the order. And the only time there will ever be any opposition to such an affidavit is going to come from effectively media. It's all very well for me to be standing up here supposedly triumphing free speech and open justice, but the reality is that when I'm in a large case like the security one, I sat at the bar table and went along with it all. I had no interest in my client's name, identity, facts being disclosed. It made no difference to me, and therefore I couldn't see how it would help. I couldn't see how my client would benefit from being embarrassed publicly. I didn't think it was going to affect his ability to get a fair trial in any way, shape or form. But when I was asked by the judge what I had to say, my position was, look, this is just a standing appearance. I will go along with whatever the decision is. It was an absolute loser from my perspective to stand up and give an impassioned speech about the overriding necessity for open courts. Because effectively what I'd be doing is saying that my client should be publicly humiliated. So I'm not going to do that. Conversely, I'm not going to say that everything should be shut down either, because that makes me look overly defensive. So my best bet was to sit there. And that's when counsel for the media comes in. Counsel for the media then stands up and actually does the work of the loyal opposition. And for those of you who practice in media law, or have friends who practice in media law, it is an extraordinary growing field. Amendments like this are not in any way, shape or form going to constrain it. But it is frankly counsel for the media, solicitors for the media, who are now the beacons saying that justice should in fact be open. So the real question about whether this reform initiative will actually prevail or otherwise comes down to the strength of the submissions that the media managed to use. And I can see that if you look at Brady's case, on the one hand, Hollingworth would have before her once again the DFAT affidavits saying that if you publish this information, if you publish this order, then our foreign relations with 3 great trading nations of ours will be adversely affected, and our ability to trade and to enter into security arrangements with them will be greatly harmed. The media can then say, based upon this, well, maybe so, but we need to look at the primacy of the principle of open justice. It's all going to turn on, ultimately, this is new. The word primacy in paragraph 1 is where the fun is going to be. what did Parliament mean by the word primacy, and to what extent does primacy outweigh the secondary considerations in paragraph 2? It is an obscure lecture series. We've both enjoyed giving it, probably a lot more than we enjoy giving our expert evidence one. And I think that this field is going to evolve greatly over the next 6 months or so. So if you're still in it for another obscure lecture 12 months from now, please come. Let's stop there, and if there are any questions, let's have them over wine outside. Go for it. No, please go. Go for it. No, please do it now.
With a New South Wales suppression order or Victorian suppression order, how can it enforce in another state, or is it doesn't have that extraterritoriality?
What Pell is showing is that a Victorian suppression order, if a newspaper was simply published in the Wentworth Courier, if the Wentworth Courier if the Wentworth Courier was to publish, had no online presence and was to publish the facts of Pell, and there was no interstate dissemination, then theoretically that could work. But we live in a world where the reality is that there are no guarantees. It's an excellent question. It's predicated on the fact that we live in an online world, and that even though the Wentworth Courier may be published only in Wentworth, someone will tweet it. Someone who lives in Wentworth will tweet it, or alternatively a copy will make its way across the border. You're right, because there have been examples in the last 12 months where a major suppressed case in Victoria was the subject of many articles in the rest of the country, and the Australian actually had to publish a Victorian edition on a number of occasions to avoid breaching this suppression order. But it was in Pell, the court made it abundantly clear that it would have zero tolerance because of the nature of the case and the consequences for Pell. The reality was, if that suppression order had failed, then Pell would have had an exceptionally strong grounds for saying that it was impossible to get a fair trial. So the nature of the order itself and the consequences what mattered. But the one where the Australian had to produce a separate edition for a number of editions, the consequences were not so much life and death. There were certainly going to be commercial consequences. There were going to be the reputation of the AFL would be called into dispute, but that's somewhat different. That's somewhat different from the reputation of it was one of the codes. I can't remember if it was AFL actually. But one of the sporting codes' reputation was going to be could have been called into disrepute if the matter had spread more widely. But in Pell, the reality was the stakes were too high. Any other questions at this stage? Let's go and have a wine. Thanks very much, everyone.